Perfect. Okay, we're recording now. All right, so in this video, we're going to talk about patents, more specifically, Amazon Seller's Guide to Patents. We did one last time about trademarks, and now we're going to talk about patents. The agenda for the presentation, initially, we'll go ahead and talk about the four branches of IP, of intellectual property. Then we'll get into the difference between design patents and utility patents, and then benefits of patents for Amazon sellers, how Amazon sellers could really utilize both design patents and utility patents, and what my thoughts are about that. And then lastly, we'll get into Amazon's neutral patent evaluation procedure. This is a newer program that Amazon created, I think maybe about 2 years ago, 3 years ago. And something that I think is going to be a lot more frequently used by Amazon. And then at the end, we'll have a Q&A in case anyone has any questions. And there's a few questions that have been emailed in. All right. So 4 branches of intellectual property. We have trademarks, copyrights, patents, and trade secrets. Trademarks protect your brand name, your slogan, and your logo. Okay, so anything related to your brand, a trademark would protect. Copyrights protect artwork, photographs, any movie, any script, anything sort of artistic. So anytime you think of copyrights, think of artistic stuff. And then patents protect inventions. That's the easiest way to describe it. And then with patents, there's a few other sub branches of patents that we'll discuss. And then lastly, trade secrets. Think of Coca-Cola's formula for trade secrets. It's not published anywhere. It's not public. It's something that they guard internally, right? Another example of trade secrets would be like any certain processes that you have within your company that is proprietary. That would also be a trade secret, and you wouldn't want to disclose it to the public, okay? So the types of patents, there's utility patents, design patents, and plant patents. Plant patents, we're not going to discuss. As Amazon sellers, we have never, at least we've never seen it in the 10 years that I've been on Amazon, any plant patents, but this would be related to companies and I guess labs that create new types of seeds or new types of hybrid plants, okay? The two that we're really going to focus on are utility patents and design patents. Utility patents protect anything functional, anything that that requires some sort of mechanism or has some functionality or utility to it. Design patents protect the ornamental look of the product. Okay, so those are the two that we're going to focus on. Benefits of patents. A lot of our clients will come to us and say, you know what, I've heard a lot of great things about patents, but just wondering, like, what do you think are the main benefits? So I outlined it here. Value increase. Any valuation of your business would increase, right, with a patent. Obviously, it depends on if it's a good patent and if it's been written well and applied appropriately. But the idea is that if you've got a valid patent, then the value of your business or your brand, your company would increase. Okay. Second is reduction of competition. As you know, a patent doesn't guarantee that no one else is going to copy your product or copy your patent, but it gives you the right to remove or exclude those other people from selling it. So keep in mind, even though you have a patent, even if it's a valid patent, you still have to enforce it, but at least you've got the ability to enforce it and remove any competitors that may be infringing on your patent. Second, sell or rent. So a patent, whether it's a design patent or utility patent, is considered an asset in itself, right? So you could either sell it separate of your business, or you could rent it out, meaning you could license it to other people. There's probably hundreds of inventors that I've talked to where they have an invention, they have a patent, but they're not manufacturing the actual product, right? What they do is they just hold on to it, or they've licensed it out or rented it out to someone else for them to manufacture or retail their products. So I think that's the third benefit. Fourth is you can get a loan. So you could go to a bank with your patent and be able to get a loan or use it as collateral for a loan, whether it's personal or business. And then fifth, with patents, enforcing them on Amazon is generally easier and a lot more effective compared to copyrights or trademarks. So that's another aspect of it. And from there, we'll also get into later on in this presentation, we'll also talk about Amazon's neutral evaluation process. So with utility patents, there's a further sort of sub branch of this of the utility patents. There's provisional patent applications and non-provisional patent applications. So what's the difference between these two? Provisional patent applications, you would file a application with the USPTO, and they would give you 12 months to sort of perfect your invention, right? For example, we had a client, I think we started helping them about 2-3 months ago, and they had a super sophisticated medical device that they want to patent, but they didn't have everything sort of figured out yet. So what we suggested and what we ended up doing was a provisional patent that gave them 12 months to then use this patent application to go find funding, go find engineers, medical engineers, and other cardiologists to help them figure out what's the best way to perfect this invention. So that's what a provisional patent application allows you to do. So the USPTO, once you file it, they'll give you 12 months to perfect your invention, okay? The provisional patent application will never become a patent. It'll expire after the 12th month. But the idea is that before that expires, you would file a non-provisional, okay? So again, provisional patent application just helps you get priority in line at the USPTO that, hey, this is my invention. Here's what the idea is. Here's what it would do. It's not fully completed yet, but I've got enough to sort of file this application. And the idea is that I will then file a non-provisional patent application, okay? And again, for provisional patent application, as soon as you file, you can use patent pending on your product or on your Amazon listings or any packaging that you may have. The non-provisional patent application, this is what can become and does eventually become a actual patent, right? So with a non-provisional patent application, it takes about a year or so for it to actually be assigned to an examining attorney. And as soon as you file, you're in line for examination. And you can go ahead and expedite the application process. There's certain things, certain criteria, fairly easy to meet that criteria. But this is what it would eventually become a patent application, or I should say patent, okay? So if you already have your product and you know exactly what it's going to do, what it's going to look like, then you would go ahead and file a non-provisional. But if you don't, you're sort of still in the planning and research and development stage, you would go ahead and file a provisional patent application, okay? And again, this is just for utility patents, not for design patents, only for utility patents. Next, I want to take a look at the difference between design patents and utility patents, non-provisional. So again, what it protects, design patent protects how it looks compared to utility patent, how it works or functions, the timeline for the application. On average, this is what we're seeing, 18 months to 36 months. However, recently, when I say recently, in the last, I would say 6 months or so, the USPTO has become a little bit busier. So this the time frame may take maybe a little bit longer, but design patents are almost always going to be processed a lot sooner than utility patents, and that's one of the advantages of having a design patent. As far as the patent term, how long do you have this quote unquote monopoly? For design patents, it's 15 years from the grant date, meaning whenever they grant you this patent. And then for utility patents, it's 20 years from when you file, okay? So that's the patent term. And then how do patent attorneys determine infringement? For design patents, there's drawings of your product from different angles. So that's what they would use. On utility patents, it would be the written claims, the independent and dependent claims. That's why utility patents have a lot more writing. They include a claim and a lot of other things. But that's that. Let me see. For estimated costs, you're looking at a design patent being around $3,000 on average, plus government fees. And then for utility patents, you're looking at over $10,000. And on average, what I tell clients is plan on spending around $15,000 with filing the patent. And if you have any office actions, having an attorney address those, and then obviously government fees, okay? Enforcement on Amazon, as far as how you enforce it on Amazon. For design patent, it's through Amazon's report infringement form. And then for utility, it's through neutral patent evaluation procedure. Now, you can also file a infringement report on Amazon using their form for utility patents. But what we have gathered from Amazon's attorneys is they're trying to steer more people towards the neutral patent evaluation procedure instead of the report infringement form. The only caveat to that is if there already is, or a neutral evaluation procedure has already been completed, then on certain occasions, they do allow that patent holder to go ahead and use the report infringement form for the utility patent. But that's just a general overview of design patents and non-provisional utility patents. Let's talk about the neutral evaluation procedure, or Amazon. I don't know why they gave it such a long name. Amazon Neutral Patent Evaluation Procedure. We just call it NEP for short, Neutral Evaluation Procedure internally here. But the person who, or the party that can initiate the neutral evaluation procedure is the holder of a utility patent. Again, this is only for utility patents, not for design patents. And then once a seller is accused of allegedly infringing on a patent, they really have a couple of options. Number one, they could go ahead and try to reach some sort of settlement with a patent holder. They can go ahead and decide to join the neutral evaluation procedure, or three, they could just not respond at all, okay? And when Amazon sends you that notice, they give you 3 weeks to either decide whether to join or not to join. So during those 3 weeks, you could go ahead and talk to an attorney and see if it makes sense for the attorney to reach out to the patent holder. And then once you decide to join the neutral evaluation procedure, each party puts up a $4,000 deposit or a bond. And the idea is that whoever prevails, whoever wins the proceeding, gets their $4,000 back to them. And whoever loses would go ahead and lose that money. That money would go to the evaluator that Amazon has sort of designated as the judge in the proceeding, right? And this judge or evaluator is just another patent attorney that Amazon has. So that's the process for the $4,000 and how to join. Once you do join, so again, just to recap, once you receive that notice from Amazon saying that this person is alleging that your ASIN, and they'll provide the ASIN, is infringing on their patent, and you have 21 days to either negotiate a settlement with them or go ahead and join the neutral evaluation procedure. You must do something within those 21 days. If your product is doing well revenue-wise, please go talk to an attorney, whether it's our law firm. We've got plenty of experience representing both sellers that are allegedly infringing on the patent, and also inventors that want to enforce their patent. So we represent and have represented both sides. One thing that you should not do is if an inventor is alleging that you're infringing on their patent and Amazon sends you that notice, please don't wait until the 19th or 20th day to go talk to an attorney and say, I've got 1 or 2 days to respond and determine whether I want to join or not. There's a lot we can do within those 21 days to help us sort of progress the case or settle the case. So please talk to an attorney, again, whether it's our law firm, we specialize in this, or any other law firm. Notify them within a day or two of receiving it. That'll give them enough time, or give us enough time, to start working on the case and drafting a strategy for you. But once the procedure does start, the evaluator will give 21 days for the patent owner to go ahead and submit their initial argument or their initial draft. Okay, and then from there, the other side, being the seller, will have 14 days to respond. And then once they do respond, it goes back to the patent holder, and the patent holder has 7 days to submit replies to the seller's arguments. The 7 days for them to submit a reply, this right here, this is optional, right? So that's something that they can do. But once this procedure has ended, think of it as like a ping pong. So patent holder has 21 days to draft and submit the complaint or the initial arguments. Then it goes to the seller. Seller has 14 days. Once they submit it, then it goes back to the patent holder. Patent holder has the option of drafting another argument or counter arguments, and they have 7 days. Once that's done, the evaluator in the case, or the quote unquote judge, has 14 days to make a decision. And the decision is either going to be that a product or an ASIN is infringing the patent. If that's the case, they'll go ahead and remove it, suspend the listing, or say that it's not infringing and let the listing go ahead and continue to sell. Okay. Any questions? So before we get to the questions from the people here, we did have a question from someone via email asking about the difference between a design patent and trade dress. So design patent and trade dress. Design patent, again, both of them protect the look of the product, right? But design patent, you have certain number of years where it's in effect. After that, it expires. With a trade dress, because it is a trademark, it can last forever. And with the trade dress, you also have to use it for it to actually be in effect, right? If you stop using a trademark, such as a trade dress, it can be, your rights can be extinguished. Where a design patent, it's only for 15 years, and after that it expires, but you never have to use it. So those are the main differences. And just because you have one doesn't mean you can't obtain the other. We've had clients where we've suggested that they get both a design patent and a trade dress. Okay. I'll stop sharing now. Any questions? Perfect. All right, I'll go ahead and stop the recording.